Well, to see what they look like, even if you don't agree with them.
Good evening, ladies and gentlemen. Just to introduce ourselves, my name's Councillor White, John White, and I'm Chairman this evening. On my left, I have my Vice Chairman, Councillor Heaney. The other councillors who are members of the committee are sitting on the two side tables, each side of the room. They're the ones who will ultimately debate and vote on each of the applications in front of us tonight. On my immediate left and right are TDC officers, including Head of Planning and the committee solicitor. This is a formal committee, and it's very important that councillors can hear all the presentations. And unusually tonight we've got a very empty gallery, so I don't suspect there'll be too much noise from the gallery. The order of business tonight will be the officer will give a presentation on each application, and then we shall have public speaking only on item A1, that is the one from Alresford. And then ultimately, if the officer got no further comments, the committee members will ask questions, debate, and hopefully finally vote. I should add that this meeting is being recorded and will be available on the council website in about 10 days' time. So now if we can just turn to the agenda, and the item 1 is apologies on any substitutions.
Thank you, Chairman. Apologies for absence have been received from Councillor Bennison, and there is no substitute for her. Thank you. Thank you
very much. Item 2 is the minutes of the last meeting. That was the 11th of December. Committee members, have you spotted any errors or omissions? And as there's no indication, is it your wish that I sign them as a true and correct record? It is. I have a proposer and a seconder. That I will do. Thank you very much. Item 3 is declarations of interest on the 3 items that are in front of us.
Gary.
Yes. Councillor Scott is indicating at the from the hall. Right, thank you very much. And although I will also make a declaration, it's the same as I did last time round, in that my daughter has a property in Tokely Road, which is one of the applications in front of us tonight, but I'm certainly not predetermined on the application that you will see in front of you. Councillor Heaney.
I also won't be sitting on that because I wasn't here last time. I know it's only about the 106 agreement, but because I didn't discuss it in the first place.
Right, no further declarations, in which case we turn now to agenda item number 4, and I haven't received any notice of questions under Council Procedure Rule 37, which very quickly then takes us on to agenda item 5, or A1 in the agenda, and that is on your page, haven't got it numbered on mine, page 10, thank you very much, and that is planning application 1801775 full. This is land adjacent to 2 Wivenhoe Road, Alresford, and I'm going to turn to Michael Pingram to outline it for us.
Thank you, Chairman. Good evening, all members and members of the audience as well. So this application before members relates to land adjacent to 2 Wivenhoe Road in Alresford. The proposal seeks full planning permission for the erection of 1 detached residential dwelling and is before the committee as the applicant works within the planning department. The site is located on the edge of the Alresford settlement in a semi-rural location. The site itself is open and laid to grass with a number of trees to its southern boundary. To the west are a large number of residential properties. These properties are of no set design. They're a mixture of single-storey, 1.5-storey and 2-storey dwellings, all with a variety of material types. So I think it's important that I firstly sort of touch on the history of the site. So members will note that in 2013, an outline application for 5 dwellings was rejected by the council as it was felt that the proposal would represent a significant extension of ribbon development outside of a defined settlement limit, resulting in a harmful intrusion into the rural street scene. This decision was upheld at appeal, where the inspector confirmed the proposal would be harmful to the character and appearance of the surrounding area. In 2016, planning permission was, however, granted for 1 dwelling on this site when the council was unable to demonstrate a 5-year housing supply. The dwelling at that time met all 3 strands of sustainability. This resulted in the site being included within the settlement boundary for Alresford within the emerging local plan. More recently, in October of last year, this committee refused 3 dwellings on this site. The reasons for this refusal was that the proposed dwellings, by respect of their large size and siting behind the existing building line within spacious open plots, would appear as a prominent and incongruous feature, and would therefore represent a form of ribbon development that would not appear in keeping with the surrounding semi-rural street scene. The application before members tonight has sought to overcome these previous concerns. The main changes between this most recent refusal and the application before members tonight are as follows. Obviously, the most notable change is that we're dealing with 1 dwelling as opposed to the previous 3. The dwelling is to be sited slightly further forward, so it's more in line with the existing dwellings. The previous garage and storage area was like a carport with the first floor as a sort of storage area. That's been removed and now replaced with a smaller single-storey double garage. And there'll be 1 first-floor window that was on the previous dwelling that you'll see in a couple of slides' time on the side elevation. That's been removed from the plans. So in terms of the site, here you can see the view looking southwest. So just beyond the sign just there is the entrance to the site. And again here's the access to the site itself. Here's a view of the site looking east. You can see it's lots of trees to the boundary just there. And then this is the site looking south. Again, you can see the edge of it by the post and rail fencing along the back there. So it's acknowledged that the site does... Hold on, sorry, I'll just go back a couple of slides first. So it's acknowledged that the site does fall outside of a settlement boundary within the adopted local plan, which you can see on the screen just here. However, it does fall within inside the emerging local plan, as I touched on earlier on. And whilst this document is not yet adopted, it is given moderate weight in determining applications. A further key consideration is that following the permission in 2016, there is an extant permission for a dwelling on this site that can be implemented. Therefore, the principle of 1 dwelling being approved on this site is considered to be acceptable. The submitted plans show that the 1 detached dwelling will be 2 storeys and serving 4 bedrooms. Whilst the dwelling will be set slightly back from the adjacent properties, it is only a marginal amount of approximately 2 metres. The dwelling will therefore help to build upon the existing strong linear pattern of development running west to east along this section of Wivenhoe Road, and the layout is considered to be acceptable. There is no set building type to this immediate surrounding area, as I touched on previously. However, that being said, the dwelling is considered to be of a good design, incorporating key features to help break up the bulk of the dwelling. These features include front and rear dormers, a front gable, a canopy, brick plinth and a single-storey side element. Further, in terms of amenity space, for 3 bedrooms or more, you're required to have a minimum of 100 square metres. This is comfortably achieved. The adjacent neighbour to the west, number 2 Wivenhoe Road, is the only neighbour who could potentially be impacted by the proposed development. However, there is an approximate separation distance of 13 metres, which will ensure the dwelling will neither appear imposing nor result in a significant loss of light. In terms of overlooking, it is noted there are no first-floor side elevation windows following the removal of the window that was on the previous design. And the only rear elevation first-floor windows, while there are 3 of them sight to the rear, their views are going to be more to the back end of this garden area. So given that and the significant separation distance there, there's not going to be any significant form of overlooking as a result. The application site is set to grass and is well screened by a number of trees along the northern boundary. Whilst the development can be implemented without harming these trees, it would be advised that they are retained for their visual merits and to help screen the site. There is a large oak tree situated in the highways in front of number 2 Wivenhoe Road, protected by a TPO, tree protection order, sorry. However, the tree will not be impacted by the proposed works. The plans also show that with the exception of the hedge to the left of the site access, all trees along the southern boundary are to be retained and physically protected during construction. Therefore, subject to conditions to secure the steps of how the retained trees will be physically protected, details of boundary treatments and soft landscaping, the impact of the trees and landscapes is considered to be acceptable. Essex Highways have raised no objections to the proposed works, and in regards to parking, adopted standards state that for a dwelling with 2 or more bedrooms, there needs to be a minimum provision of 2 spaces measuring 5.5 metres by 2.9, or if being used for a garage, 7 metres by 3 metres internally. The garage does fall short of those requirements, however there is significant room to the front and side of the dwelling to accommodate the necessary 2 parking spaces. Alresford Parish Council have objected to the proposed plans, highlighting the previous refusal of 3 dwellings on the site and stating that the site falls outside of a settlement boundary. They also raised concerns that this proposal would replace the previous dwelling approved on this site in 2016 with a large conventional home that would be highly visible. There have also been 6 letters of objection received. I'll just run through their concerns. The access point is not suitably located. The site has previously been refused for multiple dwellings. Highway safety concerns. The site is substantially outside of a settlement boundary. The pressure to existing infrastructure. The scale is not in keeping with surrounding properties or rural landscape. The visual impacts, and it does not overcome the reasons for refusal on the previous application in October. In summary, the site has an extant permission for 1 dwelling and is included within the settlement boundary of Alresford within the emerging local plan. Therefore, the principal development on this site is considered to be acceptable. The design, layout and impact to neighbours are all considered to meet relevant plan policies. While subject to conditions, there is no harm to trees, landscapes or highway safety. The development is therefore recommended for approval. Thank you very much.
Right, thank you very much. Now, on to the public speaking. I don't have a member of the public speaking either for or against. However, a member of the Alresford Parish Council, Councillor Ernie Osborne, I invite him to come forward and have his 3 minutes.
Thank you, Mr. Chairman. Ladies and gentlemen, nice to see you all again. I just want to talk about this this particular site, because this particular site has now been refused 3 times for development, and the reason for that is because it is a rural field outside the village envelope, and one of the last things that we need in Alresford at the moment are more houses. Looks like we're going to have an increase from 810. They're going to increase that by another 350 houses. So first of all, the last thing that we need as a village is yet another house. Now, approval was already given just over 2 years ago for a house to be built on this particular site that would be obscured. It would be an eco-friendly house, and very few people had objections to that because the field itself would still look as if it was a field, and it fitted in so well with the local environment that everybody thought, well, this is not a bad idea. But I mean, we've got to go back to the reason that the person that owned this land previously was really only trying to get planning permission so that they could sell the land, and that's exactly what they did. They sold the land with planning permission on it. But the planning permission is not for this damn great house that we see in front of us here. It was for a moderately sized eco house. So I can't understand why we're actually talking about it yet again. It doesn't make any sense to myself or my parish council. There's not a lot more really I can say about this, because it was done for a particular reason. I understand that it was rejected previously, and of course when you've got a bit of land and you want to sell it, you think and get planning permission on it, you actually start asking the planning officers at tendering as to what they would recommend that would be approved, get approval on this land. Well, that in fact happened, didn't it? Because it was approved, but only on the fact that it was an eco-friendly house. Now, you know, the situation really hasn't changed much since then, apart from the fact that they're trying to now build this particular large house on this site, which is very, very intrusive. Not only that, my other concern is that there's also this land around here. Now, I don't know whether a covenant can be put in place if you do decide to have this house, where you aren't able to build any more on this particular land, because I still feel that at some stage or another, what we're going to find is that the particular owner of this land will then want those other two houses that they asked for previously. I've got no more to say about it, Mr. Chairman, apart from that. Thank you very much indeed. Thank you.
Thank you very much. Ward Councillor is Councillor Scott. I don't know whether he wished to say something. Yes.
Good evening, colleagues, chairman, officers. First of all, I don't want to say too much about this, but all I can say is the residents have sent letters in, have expressed concern about highway safety. I understand that highways have no objection, but this junction is a dodgy junction in terms of cars have been hit by buses coming backwards and forwards on that junction where people park their cars. People coming from Thorrington and turn a left into Alresford, swerve round. So that kind of entrance is a kind of a blind entrance. And I just want to know whether it's possible there could be some improvements on that junction. I know Highways have said no objection, but I'm sure councillors are aware in their wards that Highways say there's no problems, but I'm sure councillors have far more experience and knowledge about their wards about highway issues, and I would like to see maybe some highway improvements there. In terms of the entrance to the site, I would like to know what the surface will be. Will it be paved, brick, or loose stones? I would like to know on that. And on the left-hand side, coming into the site, there's a row of conifer trees. I know there's a desire for the next-door neighbour to have the conifers to be removed because they are very tall, high conifer trees. And if they do fall in high winds, they are concerned that it may fall onto their property because the heights of the conifers are quite high, and if they fall over in very high winds, then it could hit the neighbouring property. So there is concern about the conifers there. Along the front, I'm pleased to hear that the officers are saying there are TPOs and protections of the southern trees. In particular, I'm quite keen for the pine trees along the southern boundary to be protected, because there is along Wivenhoe Road in Alresford there are other pine trees, and it flows nicely in Wivenhoe Road. I think that is all I want to ask, but in terms of highway safety, Chairman, I know highways say yes, no objection, but the property opposite called Elsie, they've had endless of cars go into their fence, from speeding cars coming from Thorrington, going before the flyover bridge towards Colchester, and they go into that corner, and vehicles coming up Wivenhoe Road and turning left or right, there's when they meet buses coming from either direction, it can be a little bit of a bottleneck there, and that's my concern I'd like to bring up. I also endorse some of the comments that Councillor Osborne has said from the Parish Council. Thank you.
Thank you very much. Mr. Ingram, have you got anything to say about either of those, or perhaps nothing? All right. In which case, councillors?
Councillor Cawthorne.
Yes, Councillor Cawthorne.
Thank you, Chairman.
Thank you.
I think it'd be useful to have a look at a few highlights of the planning history, if you don't mind. It might take a couple of minutes. But if we go back to 2013, the application for 5 houses, that was refused by an officer under delegated authority, and it then went to appeal, and it was refused by the planning inspector. The planning inspector noted that we didn't have a 5-year land supply, and that would normally work in favour of the applicant. But the planning inspector referred to an albeit old document. This was in 2014 when he made his decision. He referred back to a document called the Tendering District Landscape Character Assessment, or LCA. This classified the site as falling within agricultural heartland, and then he goes on to say, the arable landscape within rural settlement within this area should be conserved, and that further incremental linear development along roads would disrupt this pattern. Now, what we heard from the officer tonight was that this house would help build a strong linear pattern. But that contradicts everything we've been trying to do, I believe, for quite a few years. We don't want to build on this linear pattern. We don't want ribbon development. But anyway, that was one of the planning inspector's observations. He went on to conclude the harm to the character and appearance of the surrounding area would be significant and demonstrable. This harm would outweigh any benefit. So, okay, that's 2014. If we move on to the house that was approved, which I think was a 2015 application, there were some objections, and these were addressed by the agent, and I did quote some of this in the October application, but we also refused. And the agent here observed, and I'm sure I read this last time as well, the application is for a well-considered, single-storey, low-impact, sustainable dwelling following assessment of the immediate and wider context to arrive at a solution which is unique and appropriate to this site. It seeks a high-quality piece of architecture which would respond to the site, not harm it. Now, I understand that that was just one submission, and the officer, again under delegated authority, had to assess that with all the other factors. When we turned down the 3 houses last year, I don't think I quoted anything from the officer's report on the 2015 house, but I'm going to do tonight, if you don't mind. And this is a paragraph called Design/Visual Impact. We did hear this morning on the site visit that when this house was approved in 2015, the design of the house wasn't a factor in its approval. And that was stated by the officer this morning. And I'm going to strongly disagree with that, my evidence being the report that was produced by the officer at the time. And I'm going to quote from this. It says, the appeal was dismissed, referring back to the 5 houses, as it was considered that further incremental linear development would be unacceptable and would be harmful. Okay, that's agreeing with the planning inspector. The proposal under consideration is significantly different. Single dwelling as opposed to 5. The contemporary low-level design differs markedly to the traditional 2-storey dwellings dismissed at appeal. And we have to note that tonight we're looking at a traditional 2-storey dwelling. Right? The officer goes on to say, the design approach taken is contemporary, using locally sourced materials, including gabion walls. I had to look that up, it's rocks in cages, timber and glass. Excuse me. These materials are to complement the proposed living walls, which I'm putting in quotes, which will assist in assimilating the development into the landscape. The low height of the proposed dwelling will also help to reduce the impact if glimpsed through the existing vegetation. At this point, the officer gets a bit carried away, I think. The stimulating modern design approach, combined with a firm intention to integrate the dwelling into the landscape, would overcome the concerns raised previously in respect of harm to the landscape character. So I'm saying that the design of this house was integral to the decision made by the officer. I'm nearly done, so don't worry. If we then move on to... well, let's look... Yes, so we then get the application for 3 houses last October. We turned those down because of harm to the character of the area, and 3 or 4 saved policies. Maybe one of the others can talk about the saved policies. But I think we have a history here of turning down applications because of harm to the character of the area, and I don't think tonight's application is any different. Thank you.
Can I say something quickly? If you're not going
Yes, Councillor Haney.
The trouble is, with the inspector's report, he didn't say that the only dwelling on this site could be an eco-house. If he'd said that, we'd have to have an eco-house. But he didn't say that. So he actually gave planning permission for one house without tying it in to be an eco-house. That's the problem from, I think, what you're saying, in my view. But I'm sure the officers will tell me whether that's right or not. Thank you.
Right, other speakers? Yes, Councillor.
Thank you, Chair. Going to the Eco House and carrying on from Councillor Heaney, are we in a position at that time we made this they made this application and we approved this, and even now are we in a position to say no, but you can build this eco property because you've got planning permission to do so? Am I right? That's correct.
That's my understanding, but I will turn to the officers because it was only 2.5 years ago, wasn't it?
Yeah, sorry, just to explain. So you're absolutely right, Councillor Corfin, when you're saying that design was considered in the 2016 application. Just to sort of clarify, I guess, what I was trying to say this morning, that it wasn't treated... Design is considered, as it is with any application, and there was considered to not be any harm with the design on that application itself. But it wasn't the sole reason for why that application was approved on that occasion. It wasn't approved purely because it was an eco-friendly dwelling, I think, just to clarify.
Could you also answer the last question about there is an extant application and that could be built?
Yes, sorry, I didn't hear that question. Yes, there is an extant permission that can be implemented regardless of what is determined tonight.
Councillor Cawthorne again.
Yes, Councillor Cawthorne.
Thank you. Well, it's just coming back to the statement just made by the officer there. This is going to be my opinion now, and we will never know. But if this house, the design tonight, the two-storey traditional dwelling, had been the one proposed in 2015, I don't believe that would have been approved. I don't believe it would have been approved because it would have contradicted what the planning inspector had said the year before. Thank you. So I do believe the eco house was part of... He didn't say an eco house, but a traditional house would not have been approved, I believe.
Well, I don't think we shall ever know the answer to that. Right, yes, Councillor Everett.
Thank you. I'd like to explore another route, please. In the emerging local plan, you showed a diagram up there of the development boundary. Right. Can you tell me exactly on that area how far the eastern boundary of the property goes in terms of the application? Because for me, that red line and the blue line that you've got on the next bit don't quite concur.
No, you're right.
There was a picture of it. Michael, there was a picture up there of that red line and blue line. We did have a picture.
Oh, sorry. This one.
That one?
Yeah.
Right.
Yeah, that's a bit mysterious, isn't it?
So the blue line, where it kinks out to the left, doesn't seem to be the same as where the boundary is for the development boundary.
I thought it was rather a strange concept.
Richard, what are we looking at? Why is it...
Okay, just to answer that question, Councillor Everett. So the settlement boundary, basically, if you just follow what I'm doing on the mouse here, but it runs up the red line here and it kind of goes straight onto there. Right. It's about there. This part here is outside, but this part's in.
Okay, thank you.
Right, further points? Anybody else wish to? Yes, Councillor McWilliams.
Just for a point of interest, Have we got any figures to tell us as to what size, square metre wise or whatever, would be of the previous property that was actually approved and what this one would be as well? I'm just wondering if that's available.
We'll try and find that out for you.
I think we can talk about this one that was approved. It certainly seems to be, how shall I put it, a building that I wouldn't want to live in. If you wanted to get from one room to the other, you've got a 100-yard walk on it. But that's a personal view. There must be some other questions while we're searching for searching.
I'll ask a question, if I may.
Yes, please.
The member of the parish council who was speaking, Councillor Osborne, brought up the fact about putting a covenant on the land. We couldn't obviously put a covenant on the land because that is a legal. I think it's a legal thing you have to do with solicitors, and I don't honestly think they're worth the paper they're written on. But are we able to put on something that says the rest of the land shouldn't be developed? Question to the officers if they heard. Yeah. Is that right?
Yes, it is. Whilst the officers are searching there, I asked the solicitor. Question is, if we were to approve this one, could we put a covenant on the remainder and say there'll be no other buildings on it? I think I'm right in saying, but you'll tell me, that would not be possible to do, but I'm...
So yeah, you've got the difference between obviously a private covenant that's to do with the land ownership and landowners, and then a planning condition. So the only thing that obviously planning members could try to impose on any planning application is a planning condition restricting certain uses for the future. The planners would need to give any advice on whether that they think that would be an appropriate proportionate condition, meeting all the tests for conditions in this particular instance. Usually a condition restricting certain types of future use is only obviously justified if there's evidence to show there's going to be some kind of harm. So I'll let them give some advice on whether that particular condition might be appropriate here. Covenants, though, is something private, and that's not something that members would get involved with.
Councillor Hone had indicated first, then I'll take Councillor Everett. Oh, you've got some answers, right, let's take that.
Thank you. Sorry, to Councillor McWilliams, just to answer the question from before. I can't give you the exact floor space, but the 2016 permission has measurements of 54 metres in width by 19 metres in depth, and the current application is 17.5 metres in width by 11 metres in depth. But, of course, this one is 2 stories. Oh, yeah, sorry. So, the previous application, because of its shape, its widest point is 54 metres, and its deepest point is 19 metres, but it is of a peculiar shape, so it can vary.
Right, Councillor Hone?
Yeah, I've just noticed on here, removal of permitted development rights for boundary treatment. Can you tell me exactly what that means?
Yes.
Yep, sorry, to answer that, I think that was a slight typo on my behalf, so I apologise for that. But what it should say is condition 7 should be the removal of PD rights on the site. So that can restrict any future outbuildings or things like that being... No, well, you'd need permission for another house separately anyway, but you can have permitted development rights to build an outbuilding, for example, at a particular dimension, but that will remove the potential for doing that. And the rest of the sentence should have been the condition to find out details of the boundary treatments. So it's an amalgamation of two conditions that are sort of merged into one sentence, so my mistake.
Right. Councillor Everett.
Thank you, which leads me beautifully into what I was going to ask, and you partly answered the question, I think. So just want to be clear here about what you just said and whether it accords with what I think I was going to ask. I was going to ask, picking up from what Charlotte said, would there be any way that we could restrict any further development of this site other than what's actually in front of us today? And I think what you've just said does say exactly that the permitted development rights being taken away would prevent any further use of this without first gaining planning permission. Is that correct?
Yeah, to answer your question bluntly, yes. Removal of PD rights won't stop something potentially being built, but it will mean that any outbuilding or anything like that would need planning permission. And for we can't restrict any future applications coming in, whether that be for an additional dwelling or outbuilding, whatever it might be. But everything would get judged on its own merits on that occasion. So removal of PD rights doesn't restrict them never having an outbuilding. It just means that they would need to go through the proper planning processes first.
Right. I look to you now. I think we've had nearly over the subject quite well. I look for a proposal. And Councillor McWilliams.
I'm going to take the initiative, and I'm actually going to propose that we actually approve this application. Thank you.
Thank you. And Councillor Fowler.
Thank you, Chairman. All things being considered, the concerns from the speakers regarding the highway safety, again, of course, the standard comment from Highways, I'm happy to second Councillor McWilliams' proposal for approval.
Thank you very much. Do we need any further debate? If not, I'll put that to you.
Do we have to add the PD rights in conditions?
No, it's under item 7 of the conditions.
So that would be split into two conditions.
Yeah. So you know what you're voting for. You're voting for the recommendation of approval with conditions 1 to 7, but item 7 will be split into two separate sets of words.
Will you make another condition, number 8, or will it just be...
Yeah,
so we agree that it's 8, not 7.
Correct.
Yeah, that's it. Right. I'm going to ask you to vote on it now. Those in favour, please show. 1, 2, 3, 4, 5, 6. Thank you. And those against? 2. And therefore 2 abstentions. That is right. So that application with the slightly amended conditions is approved. Thank you very much. Now we move to agenda item 6, that's A2. It's a planning application number 18-00194. And this is land north of Tokely Road, Frating, and it is a full application for the erection of 67 dwellings. And turn to Suzanne for this one.
Night.
Right. Thank you, Chair. So this is an application that relates to land north of Tokely Road in Frating and a permission for the erection of 67 dwellings. The application came before members of the Planning Committee on the 26th of June 2018, where permission was granted subject to a legal agreement and a series of planning conditions. Following the Planning Committee's decision, a need for healthcare contribution was identified and the amount of education contribution has been clarified. The proposal before you this evening is for the additional Section 106 requirements as set out in the officer's report to be included, and the time for which the Section 106 to be completed extended from the 26th of December to the 26th of February 2019. So whilst the proposal has not changed in any way, I'll remind members of what was previously considered. So the site is located to the north of Tokely Road and the east of Bromley Road. The main vehicular entrance, well, the only vehicular entrance, will come from Tokely Road, and there is proposed to be a footway cycleway onto the Bromley Road. This is the site here. So as you'll see, it's an arable field with existing residential development on two sides. And here are some photos showing the access onto Tokely Road. And this is a view of the properties in Tokely Road, so you can see they're predominantly two-storey in height with brick finish and detailing. And this is looking across from the western boundary, looking southeast. And again, looking from the western boundary across the site to the east. And this is the area of the proposed cycleway footway. This was a layout that was considered and given a resolution to grant. So, as I said, there's 67 dwellings, it includes 2 bungalows in this location and a collection of masonettes, which are still two-storey in height. There's been no changes to the layout since previously considered, and that shows it in context with the surrounding development. And this is indication of the design. So, as I say, there's been no changes, but you'll see that the design reflects some of the characteristics of the existing dwellings, but with a slightly more modern appearance in terms of the window detailing. And again, that was considered acceptable with no changes made. And in terms of parking, that is in accordance with the standards. So to summarise, the built form and layout of the site has not changed since the previous decision by Planning Committee to approve the application. The consideration is if it's reasonable for the additional request of healthcare contribution to be added together with a further 2 months to complete the legal agreement. Thank you, Chair.
Thank you very much. And as I said earlier, we've got no public speaking on this, so councillors, it's over to your good self. It's just been explained that really the only difference is now that we are so near the Section 106 agreement, and that's why it's been brought to you. The figures are on your in the recommendation. You'll see there's a number of affordable housing on there, additional open space, and then the education contribution, that's all been agreed, and the healthcare contribution has been agreed as well. So, let's have some speakers on this. Yes, Councillor Baker.
Just one question. Is the 26th of February going to be achievable? Because it's only 6 weeks away. How close are we to signing?
Right.
I suppose it's in the hands of the solicitors, but that is a date that's been given to us by the considered reasonable by the applicants. There has been a first draft already circulated, and comments have come back on that. So we are sort of towards the end of the process.
Please.
I'm just thinking, if it's not enough time, does it make any difference if we give an extra month? Just to make sure, because what I don't want to do is, or I wouldn't want to see is, unfortunately we haven't achieved this, can you give us another extension? So how about saying the 26th of March, and I'm quite happy to propose, if that's okay with the rest of everybody.
I'm sure we can put a condition in saying subject to it being agreed. Yes, Councillor McWilliams.
I'm actually happy to second that, and with that extension of a month, because I had the same feeling. If anything were to go wrong, why bring it all back again? You know, it'd save a lot of time if we've just given that extra time.
Yes. Councillor Everett.
Thank you. I'm always interested in these reports that everything new's all in bold. It's very handy. It helps me to find what's going on. So does this mean that since we actually last looked at this, that in fact we've added a healthcare contribution and clarified some education contribution? Because if that's the case, then I'm really pleased to see that.
Yes, that is the case. We received consultee comments from the healthcare who requested a contribution, and so education have then clarified through their consultation response exactly where it's going. So yeah, there are additional requirements.
Thank you.
Further comments? You have in front of you... Oh, I'm going to ask the officer, what wording shall we be able to put in front of this to say, subject to the 106 being agreed, then we ask Head of Planning to grant the permission?
I mean, my view is that you just need to change that date, so you amend the recommendation to say by the 26th of March. I don't think it necessarily needs agreement from the other side, because we can always issue it earlier if it has been completed.
Right, and that's accepted by the proposer and the seconder. In that case, I'll put it straight to the vote without further debate. Those in favour of approving this as listed with the conditions, all 22 of them, on the adjacent sheet. Those in favour, please show. Add my two penneth.
And I'm not taking part.
And thank you very much. So that is approved. The Vice Chairman wasn't on the site visit and therefore didn't take part in the debate. So, right. And now we turn to agenda item 7, which is the redevelopment of the Cliff Hotel at Dovercourt, item A3, and turn to Suzanne again.
Right, thank you, Chair. This is an application that relates to the Cliff Hotel in Marine Parade, Dovercourt. Permission for the demolition of the hotel, function hall and outbuildings, and provision of a new Art Deco style apartment block, which consists of basement parking, 20 apartments, a bar and restaurant, together with a 61-bed hotel to the rear of the site. Again, this is an application that members have seen before. It came before members of the Planning Committee on the 31st of October 2017, where permission was granted subject to a legal agreement to secure off-site open space stroke play equipment and a financial contribution towards the park pavilion. Since this decision, a viability report was submitted to the Council and has been independently assessed. The Council's independent assessment concluded that the scheme generates a deficit, and on this basis the scheme is not viable, and in light of this advice the application is brought back to the committee with an amended recommendation, which is not to require a legal agreement or financial contributions. So the proposal has not changed in any way, but just to remind members, also since the previous committee decision, there's been updates in the local plan in terms of the position with the emerging local plan, and also the new National Planning Policy Framework. But it's considered that these do not introduce any issues that would alter the considerations of the application as they were taken previously. So this is a site with a footprint of the original building, and it's located in a predominantly residential area with apartments either side and resident and dwellings to the rear. The site is in this location, so it's located in a sustainable location close to the high street and to the beach and seafront. In terms of the photograph, this is how it looks, or the original building. So that's a view from Marine Parade, and that was the entrance point. That is the rear from Brooklyn Road, so the rear of the building. And as you can see, it's a fairly substantial building. That's the view looking across the rear of the site. And again, the entrance looking from the rear of the site. Recent photographs show that some of the demolition has taken place. So this is what currently stands on the site. So the area that's been demolished is sort of that side element. In terms of the proposal, as referred to in the description, the majority of the parking spaces are shown underground and will be accessed from this point here, with the red being the few spaces that will be above ground. In terms of the design of the building, this shows the relationship with the surrounding area, but it has an Art Deco appearance with predominantly rendered finish. But again, just to remind members that this hasn't changed from what was previously considered. And that just shows how the bulk of it would be broken up from the side elevations. In terms of the proposed use, the commercial element is shown in green to the front of the site, with the blue being the apartments and with the hotel accommodation located towards the rear of the site. And that sort of follows on the first floor plan, the second floor plan, and the third floor plan, and the fourth floor plan. You'll notice that the area of hotel is decreased as the building steps further away from the boundaries and rear boundary of the site. And on the fifth floor, there's just a masonette apartment, which is set significantly back and smaller than the rest of the area. So the built form and layout of the site has not changed since the previous decision by Planning Committee to approve the application. The consideration is in light of a viability report of whether the proposal is acceptable without any legal agreement or financial contribution. Thank you.
Sorry, no public speakers on this, and as Councillor Everett has just commented on, the alterations to the ones that we originally saw have been highlighted, and principally the design hasn't altered at all, as just been told by Suzanne. This is purely the principle of the fact that the applicants and also the independent valuation in the viability report say the property is highly unlikely to be viable with a Section 106. So that's what we're talking about this evening, whether we can drop that successfully. Councillor Everett.
Thank you, Chairman. Question for the officer. Your report mentions paragraphs 187, 127 and 92 of the National Planning Policy Framework. And those, well, 187 was the old policy framework, presumably, replaced presumably with 127. But you don't mention paragraph 57 of the National Planning Policy Framework. That's the up-to-date one. Would you read that out to us, please?
Yes, certainly. So paragraph 57 states that where up-to-date policies have set out the contributions expected from development, planning applications that comply with them should be assumed to be viable. It is up to the applicant to demonstrate whether particular circumstances justify the need for a viability assessment at the application stage. The weight to be given to a viability assessment is a matter for the decision maker, having regard to all the circumstances in the case, including whether the plan and the viability evidence underpinning it is up to date, and any changes in site circumstances since the plan was brought into force. All viability assessments, including any taken at the plan making stage should reflect the recommended approach in national planning guidance, including standardised inputs, and should be made publicly available.
Thank you for that. Do you have any comment about that?
I suppose only in what is set out in the report that the viability assessment was done. It's been made publicly available and independently assessed, and as officers we take the advice of the independent assessment as the experts in this, that the scheme is not viable, and to enable a scheme to come forward it's considered that an exception has been demonstrated.
Thank you. So, would it be appropriate for us as a committee to still insist on having affordable housing or whatever, given paragraph 57 of the MPPF saying that all applications should be assumed to be viable at the beginning?
Good point, isn't it? They all should all be viable.
While the officers are discussing it, Councillor Baker, I'll call you and see whether we...
Thank you, Chairman. I was just trying to digest what Councillor Everett said. Obviously, there's a statement put in paragraph 6.12 on page, it's the last line of it on page 53. Given the outcome of the viability report, is the officer's view that no financial contributions should be sought. So going on from Councillor Everett's question, can it be that this committee's view is that financial contributions should be sought? Yeah.
Right. You could, yes, reply to that one first.
Yeah, just to come back to those points. Obviously, it's up to members to make whatever decision they wish in terms of that. So there is a possibility that members decide that actually they want a contribution. I think in terms of paragraph 57, if I just come to that, where it states that planning applications, well, the first section is where up-to-date policies have set out contributions expected from development, planning applications that comply with them should be assumed to be viable. So my understanding of that is where you've got sites in up-to-date policies in terms of allocated sites where you'd look specifically at that site, and also in general that the policies, that those sites are assumed to be viable, I suppose. And in terms of this, it then goes on to say it's up to the applicant to demonstrate whether particular circumstances justify the need for the viability assessment. So that's what they've done in this case, that they've justified that through the submission of a viability assessment that has been independently assessed.
Right, Councillor Cawthron.
Thank you, Chairman. We have two viability reports, one produced on behalf of the applicant and one produced at the request of the council. The applicant's report talks about a profitability of 11.1%. The report produced on behalf of the council disagrees with that quite substantially, and he talks about a 5.38% profitability. And we read somewhere that 15 to 20% is maybe a normal figure a developer would be looking for. The chap who wrote the council's report, this is quite worrying, I think. At this level, the 5.38% that he assesses a profitability, at this level, I consider that the scheme may not be deliverable. The council should consider whether this type of scheme is suitable for the application site. So it's not a question of whether the scheme's not viable with the 20,000 or whatever it was, Section 106. There seems to be a much bigger question here about whether the scheme is viable at all. Thank you.
Councillor Brown was the next one to indicate.
Holmes and then Baker.
Thank you, Chair. Councillor Cawthorne's largely covered my question. I think it should be an obligation that they should make some contribution. That is my personal view. It's a huge scheme. It's multi-million pound. As a matter of obligation, I think there ought to be at least a small contribution. That's my point.
Councillor Baker.
Holmes and then Baker.
Oh, Councillor Holmes, sorry.
Where do I start? I can't get this viability right. Builders are builders. When they go into construction, they make sure that they're going to make a profit. We pass whatever we pass on the assumption that it is viable. For them to come back after we've passed it, I think is, well, I would find it impossible to do, because they would have to put up to either the price of the house. I mean, the fact is that they've got flats in there that they can put the price up. I mean, they can easily make that £22,000, isn't it, I think? Was it 22 or 20? Yeah, 28, wasn't it? Weren't a lot of money, was it?
It was 28, was it?
I mean, the fact is, I'm sure that, you know, they can't come back to us and say, well, we've underestimated what we're going to make on it. I find that very upsetting, personally, because we've passed it on that they were a capable and competent firm. So
it's no different that really from a builder and an estate who comes back to us after we've said there's so many affordable houses to be on the estate, to say, well, it really isn't viable with that number, but I'm quite happy to have a reduced number. Yes, and they're allowed to do that at the present moment until the government alters it. I understand what Councillor Holmes is talking about. I think the 22,000 was the donation towards the Parks and Gardens, if I'm right. Yes, I'm going to ask Suzanne too.
And it's Baker and Cawthorne again.
Okay, just to try and clarify this and to be address what Councillor Holmes says. To be fair to the applicant, at the time the previous decision was made, they submitted a viability assessment to demonstrate that affordable housing wasn't a necessary requirement. And so the applicant's viability assessment sought to prove that the affordable housing wasn't required, and as picked up, there's a difference in interpretation in the figures. So their viability said that, you know, they won't make a profit. I think it refers to sort of 5% or whatever like that. And all the indications is that they're happy with that level of profit. They put the application in, they were aware that that was the level of profit to be achieved. I mean, it's down to them how they decide to do the site and whether it's viable. It's not for us in every case to consider the viability. It's only where there is contributions that we have to consider it. So I'm assuming if it's not viable, it won't come forward as a scheme. And the difference has been because of when their assessment was when their viability was independently assessed, it was sort of indicated that it was worse than they expected, which is why the recommendation is for no longer asking for any financial contributions.
But surely we make a decision based on a viability. You know, our decision is made that what we agree to here is based on them building that. I mean, we shouldn't be involved with any cost or anything else apart from the 106. It goes to wherever it goes to. I think it's county, isn't it? And then it comes back to us in some other way. But either way, that is the only decision that should be able to come back to us. And this has come back to us because now they're saying it's not viable. I've been on here 4 years and I don't believe I've had one planning application so far that has not been, after the fact, declared non-viable. I've never seen it before, so I can't understand that situation.
I think, I just wanted to pick up on the options available, which was a couple of things that people mentioned about whether you can obviously, decide to not progress with it, decide to ask for the contributions even though the evidence presented and concluded by the officer is to the contrary. Obviously the same principles apply as your normal decision making, so you just need to think about the reasonableness of what you're asking, because that will be what will be examined once the decision's been made. So the guidance on viability, which was updated after the MPPPF, being updated in July, it says the weight to be given to a viability assessment is a matter for the decision maker having regard to all the circumstances in the case, including whether the plan and viability evidence underpinning the plan is up to date, any change in the site circumstances since the plan was brought into force, and the transparency of assumptions behind evidence submitted as part of the viability assessment. So obviously you've got the two viability assessments, the one submitted by the applicant and then the one that the council has sort of commented on that. So that's your evidence, expert evidence that's been presented. If you want to depart from the conclusions in those, you obviously just need to think about what reasoning you've got to do that. So it needs to be sort of robust evidential reasoning in order to be sort of defendable.
We never got these viability studies until now. Yeah, I mean, this is the only time we got it, and we're expected to make a decision on it tonight. I mean, I don't think we ever get a viability study, do we?
We do if we ask for it.
Well, okay, if we ask for it. We haven't done because we've never had the problem.
Quoted some 5%, but in the independent viability study, they think it should be, it's now calculated at 11.1%, still below the target margin set. That most builders want at least 15 to 20%, but they are now saying 11.1% in the independent report that we only got today. So, yes, Councillor Cawthorne.
Well, I wasn't aware of a report coming today, but I did take these two reports off the planning portal this afternoon.
Right.
I've just realised that my previous comments were actually I just realised my previous comments were a statement. I should have ended it with a question. Just to reiterate, the report that I took off the planning portal today, the report requested by the council says he disagrees with 11.1, calculates at 5.38%. At this level, I consider that the scheme may not be deliverable. The council should consider whether this type of scheme is suitable for the application site. There's no mention of this in the report. What is the council's opinion, or the planning department's opinion, of this chap's conclusions there? Thank you.
Suzanne, would you like to comment now, or shall I take two more speakers?
Can I have a quick look? I'm with it.
Well, are you ready to comment on that so far? Okay.
Yeah, so in terms of reference to that, I mean, I think if the council were, if it were to be an allocated site, I think the council would potentially reconsider it if the policy was obviously if we had a policy putting forward a scheme. Obviously this is a scheme that's been put forward by the applicant, and that their view is that they'll get 11.1% profit, and we can only assume that they're satisfactory. That's satisfactory for them. If that's not the case, then they'll come back to us to amend the scheme if necessary.
Councillor Baker.
Thank you, Chairman. Then Yes, I think I know how you've answered that. In other words, if it's not viable, then they'll come back with either a reduced scheme and a different application. My question is the what if, unfortunately, is what happens if we say, yep, fine, don't give us any money, don't give us any contributions, and suddenly they get 30% profit. So they would be able to make a contribution. Where do we stand then? I presume we stand... hold on. Obviously, at the moment, they're saying that it's not viable to make any contributions, but we don't know in the future what profit they're going to be. It's a prediction, and a prediction is just that. So it's the what if they make a bigger profit than they think they will. Where do we stand in saying, actually, now you can make a small contribution?
Yeah. I think originally that was Councillor Hone's point, that there isn't a clawback, unfortunately, if we let them off. Yes. Suzanne?
Yeah, if members feel necessary, in other cases you can put in a clawback mechanism, so a legal agreement that says a review if it's not commenced within X. So a review, so if it's not commenced within a set time, they will revisit the viability if they made more. I mean, in this case it hasn't been suggested just because it is so, our independent assessment says it is so clearly unviable that it's considered that even if it were to be implemented, they have 3 years in which to implement it, that whether, the view is that wouldn't change significantly enough to make it a view, but it's something we can put in if members felt necessary.
I must admit, my opinion is what if we were to grant it without any of these 106 agreements, and they came back and said, well, it's still not viable. What do we do with a great big hole on the seafront in Dovercourt? And that is a risk that only we can take, I think. We can say, well, yes, it is or it isn't, and will be acceptable. Yes, Councillor Baker.
If I can just comment on... I understand what you're saying, Chairman, but, I think other members are of the same opinion. It is a large scheme. So, yes, there's an opinion of an independent assessor saying, actually, this isn't going to make a profit. Yes, we have to follow his expert guidance because he is an expert in his field, but I still think that we don't know what's going to happen, and neither does he, expert or not. So I would like to see... I mean, if they come back in 3 years' time having done and said, look, actually, here's our viability, we've actually only made 2% profit, then I would think the committee will say, OK, fine, not a problem. But at the moment, I think we should have some sort of mechanism in that's been suggested.
Everett and Cawthorne.
Councillor Everett?
Thank you, Chair. Yes, going back to this, the report prepared for the Council again. I read this afternoon, and I thought the chap in that report had a concern that they'd have trouble financing this scheme at the 5.38, if he's correct with that calculation. I can't find it now, but I don't think I imagined it. But I can't actually find it. But what he does say in his conclusion of the report, if a council is prepared to consider granting consent with less than policy compliant affordable housing and or Section 6, I would recommend that if the scheme is not delivered with an agreed timescale, that an automatic viability review be triggered. He doesn't say what that timescale is. If they can't get financing, the scheme is going to sit dormant, deteriorating in the weather and whatever, it's deteriorating already. Is he suggesting that, say, after a year, if nothing's happened, that we trigger an automatic viability review? That's what I'm imagining, but I could be wrong. Thank you.
Who else? Councillor Everett, were you following Councillor Cawthorne or not? No, I wondered if Councillor Everett wanted to follow it. While we're just...
Not really, it's picked up all exactly what's just
Councillor Holmes in that case.
Yeah, first of all, I'd like to apologise to the officers. I just realised that, as I say, nearly 4 years on the planning, and I've only just realised what an actual viability is. I mean, I'm not saying it's ignorance, I'm saying that all through what we've gone on planning, it's never been really assessed or explained. Obviously, I now know that I can get every single thing I want off the net, which means I've got to go onto the computer a bit more. But I apologise with that, but I still maintain that we base our opinions, and obviously we do, on the builder having, a right viability. I mean, as far as I'm concerned, we should make them pay, and if they have to, excuse me, if they have to, they can bring it back for a change. I mean, they bring it back for a change anyway. The windows are big enough, or the roof's not the right size, So we, as far as I'm concerned, we should make them pay and then bring it back. Otherwise, we're going to be, if one gets away with it, I think it's just going to snowball, personally. So I say make them pay the 106.
Head of Planning.
Chairman, I don't know if it might help if I just summarise what I think the options for committee are. So if committee feel that they have considered the recommendations to the viability reports, they agree, if you like, we accept that advice, they could grant planning permission as recommended with no requirement for financial contributions towards infrastructure. Second option would be accept that advice at the moment, but be alive to the idea that valuations change, the viability might improve, and therefore follow the second part of that advice, which was to put in an automatic trigger, and we'd need to decide when that would happen. You might say if it's not commenced within a year or within 18 months, that would trigger a review. The third option would be if you think the development is unacceptable without any contributions towards infrastructure, then you would refuse planning permission. My only couple of comments on that. One would be when you considered it 15 months ago, there was no suggestion that without any contributions, that would be the view. And secondly, given what we now understand about land values in that area, if this scheme, if the committee is going to insist on full contributions for any scheme that comes forward, the consequence might well be that the site does remain empty and undeveloped for a long time. So I think there's sort of a little bit of pragmatism perhaps around that. You just need to weigh up the benefits of that. So it might be, I think, that the debate seemed to be heading perhaps towards that middle option of no contributions at the moment, but have an automatic triggered review if it's not commenced soon.
There's Maria.
Yes. Councillor Fowler.
Thank you, Chairman. I know this isn't really for us to consider, but it's in the report, in normal circumstances, that the proposal for the 20 apartments would generate the affordable housing contribution in the case that the applicant considers that the cost of demolition and necessary site remedial works make the scheme unviable with the affordable housing element included. Well, I'm sure a lot of developers have that problem where something overruns in cost. I mean, even I had to get a bigger skip earlier this year, so you do. that's part of it. But just listening to what Mrs Bicknell just said, option 2, to me, seems to be the more sensible option. So I would like to propose option 2.
Chairman, I'll second that.
Right. Thank you.
Richard, let's talk.
Chairman, I'd second that with just sort of with a bit of advice from the officers of what would be a reasonable amount of time. So either 18 months or 2 years. I don't think any longer than 2 years would be reasonable.
And Richard wants to say something. Sorry.
Yes. Well, I've got a proposer and a seconder. I'll have a little debate on that.
Thank you. I'd just like to open up the question. Given that the developer has actually started on site, would that actually be relevant?
That's an interesting question. Demolition has started on site, which isn't necessarily the implementation of the planning permission, because they could have undertaken demolition. So, but we perhaps need to be very careful about the wording of what will trigger the review process, so that it's about commencement of the actual building, whether that's groundworks for the foundations, or we'll get some words that catch that.
Kath, do we pay for this? If it triggers, do we pay for that? The viability studies, or do we have to have our own one if it triggers off?
The applicants pay our costs in assessing their viability assessment.
Okay, thank you very much.
Okay, as a proposal has been put forward, I was going to, wasn't going to speak, but I just want to say that £22,000 is a pitiful amount when you think that must be a multi-million-pound scheme. What does £22,000 buy you that they can't afford when they're doing that? What is it the cost of? 3 kitchens, something like that. Three kitchens from scratch. It's not a lot.
No. The figures that appear in the viability report is that the total scheme cost around 8 million. That's 4.06 for the residential bit and 3.89 for the hotel. And the net result on the latest estimate of land values and building values says that will equate to an 11% profit, which of course under normal developers are looking for 15 to 20%. Yeah, I think so. So proposer and seconder, if there's no further comments on it, 2 years I'm told is a reasonable period. Yeah, I asked the solicitor on the advice.
I'm wondering, and looking at the plan slightly for this, normally there would sort of be industry standard type clauses that would be used in the Section 106s for these clawbacks. So if we say that we're minded around the 18 months to 2 years, I think that's what we just said. Did we say, or did we say 1 year to 18 months? 2 years, and we put that forward to the solicitor, who isn't me, that negotiates these, but sort of gives them a little bit of flexibility to use the industry standard so that we don't keep ping-ponging back to committee if that's... they're obviously acting for us in our interests based on what you've said, so, yeah, okay.
Right, in that case I have a proposer and a second for what was described as... Yep.
So from the date of this decision.
The date of this permission, 2 years. Are we agreed on that?
Yeah, shall I just summarise it? Okay, then just to summarise, I think what we've got is an amendment, obviously, to the recommendation to have a Section 106 only dealing with clawback and looking at viability triggers, and we're aiming to do that within 2 years of the date of the decision notice being issued, subject to a bit of negotiation delegated to your solicitor acting on behalf of the council with the Section 106 agreement. Is that happy with the proposer and the seconder? Yep. Okay.
Right. I jump in without any more comments then. Those in favour, exactly as it has been outlined by the solicitor. Those in favour, please show. And that is now unanimous. Thank you very much for that. Finally, that does bring us to the end of our meeting. Thank you all very much, and I think it must be a record finishing at 7:25.
It is.
There were times when I thought we might even get 7, but it has been extended a little bit. So thank you all very much. Thank the officers and the bearing members of the public that have managed to stay.